Good morning or good afternoon, everybody. My name is Karen Steward. I'm a lawyer at the Advocacy Center for the Elderly. Thank you for joining us today. Today's topic is the second part in a series that we're putting on, a town hall series, legal strategies dealing with health and personal care. So we'd like to begin today by commemorating the Indigenous peoples' principal kinship to the land, the fact that they have not and cannot be erased from her, our collective First Mother. We acknowledge that we, particularly the ACE offices in Toronto, sit on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaty, signed with multiple Mississaugas and Chippewa bands. So, being lawyers, we like to do a disclaimer that this presentation contains legal information. It's for educational purposes and is not legal advice. So if you need legal advice for a particular issue, please consult your own legal advisor. A little bit about ACE to start. We are a community legal clinic from Legal Aid. We're funded by Legal Aid, established in 1984. We're the only legal clinic in Ontario specializing in legal services for older adults, and in our case, low-income older adults. Our mandate is to provide summary telephone advice, direct client representation, law reform and policy development, and things like this, community legal education. We're made up of 6 lawyers, an executive director, 2 institutional advocate lawyers who do long-term care, hospital discharge work, 3 staff litigation lawyers, which includes me, 3 licensed paralegals, an office manager, and a community outreach coordinator, who's Kimberly, who you met earlier. Currently, due to COVID-19, at the date of this presentation, we're providing services mainly over the phone and virtually. So just to start today's discussion and to center it in the big picture, we look at what decisions does a person make in their life, and the law divides that into 2 main categories. Property decisions, which doesn't just mean houses or property that you own, but it's money, personal goods, furniture, bank accounts. And then personal care decisions, which are decisions about your shelter, your nutrition, hygiene, safety, clothing, and healthcare. Our executive director, Graham Webb, covered property decisions in the town hall last week. So I will not be dealing with property decisions in my discussion today. I'm going to be focusing on personal care decisions. And what I hope to accomplish at the end of this presentation is to answer questions like, what is a power of attorney for personal care? When does it come into effect? What if I don't have one? And what if I become incapable and haven't made a power of attorney? Who makes my decisions for me? And so before I dive into all of that, I also wanted to start out with some just general topics about mental capacity, because we're going to talk about capacity a lot in this presentation. Who makes your decisions when you're capable or not? And so what does that actually mean? So capacity is context specific. So it's when you're talking about a person's mental capacity, it's not usually an all or nothing concept. We can talk about decisional capacity. Is this person mentally capable of making a will? Are they mentally capable of consenting to a particular treatment? Capacity can fluctuate. There are people who may be capable of making a certain decision after certain medications have kicked in the morning, but perhaps not during the day, or perhaps they have a health condition that ebbs and flows and can fluctuate, or perhaps they have a particular health condition right now that could impact capacity, but it may be different in the future. So it's not something that we generally see as static, that it's something that we look at on a decision by decision basis. And so a person can be capable for some purposes and incapable for others. So you may not be capable of making your own financial decisions, but you might be capable of making your treatment decisions. And it can even get more specific than that. It could be a person is incapable of taking a particular psychiatric medication, but be capable of consenting to the side effect medications. So it can, like I said, it can fluctuate with time and depending on the different decision. When we're talking about personal care and presumption of capacity, we're talking about adults and people who are 16 years of old and older. And so my discussion today will be mostly focused on adults and not on children, and 16 and older. In Ontario, a person is presumed capable of making personal care decisions if they're 16 years or older. And unless there isn't any evidence or reasonable grounds to believe that that person is not capable of giving or refusing consent. So there's a general legal test about mental capacity, and it's a two-pronged test that involves, does the person have the ability to understand information relevant to making a decision? And that we're sort of talking about the cognitive ability. Do they have the cognitive ability to understand the information? And then the second part of the test is, are they able to appreciate the consequences of making the decision or not? And in that part, that balancing the consequences, different people will come with different answers. And so it doesn't mean that it's a decision everyone has to agree with. Do they have the ability to weigh that choice and justify that choice? Capacity is not a score on a test, like a mini mental exam. It's not a diagnosis of dementia or Alzheimer's or any other mental health condition. It's a legal test. It's a legal determination based on this analysis of whether you have the ability to understand and appreciate information relevant to making a decision. So when we're talking about personal care decisions today, we're applying that into this capacity test. So it's the ability to understand information relevant to a decision about healthcare, nutrition, shelter, clothing, hygiene, or safety, and the ability to appreciate the foreseeable consequences of making or not making a decision. So this is very general, who assesses capacity? And the short answer, it's different people depending on the decision. So some examples can include lawyers or service providers when they're taking a direction from you. And so they would make that assessment. If I'm a lawyer and a client is asking me to do something, I make my assessment of whether they're capable of instructing me. There are also a group of people called capacity assessors. These are certain types of health practitioners who have particular education, liability insurance, and they are registered in a place called the Capacity Assessment Office. And they can assess a person's ability to manage property, which Graham talked about last week, and very certain personal care decisions, which I'll talk about later. There's also a group of people called evaluators, which I'll also get into more later. They're types of health practitioners who make the decisions if a person's capable of consenting to their admission to long-term care or making decisions about personal assistive services, like the activities of daily living, for example, in long-term care homes. And then when we're talking about treatment decisions, it's whoever that healthcare professional is who's suggesting the treatment. So that could be a doctor who's suggesting you need a particular treatment. That doctor will assess your capacity to consent to that treatment. If it's a physiotherapist, it would be that physiotherapist who assesses your capacity. So it's different depending on the decision at issue. So personal care decisions. In Ontario, if you are capable, mentally capable of making your own personal care decisions, you make those decisions yourself. The question is, who makes your decisions if you are no longer capable of making the decisions? So, like I said, as long as you are capable, you make the decisions yourself. And while you are capable, you can choose who you want to make your health and other personal care decisions. In the event that you become no longer capable of making those decisions, by creating a power of attorney for personal care. And there's also, since we're talking about capacity so much, you have to be capable of making a power of attorney for personal care. And I'll talk about that as well. So what is a power of attorney for personal care? To be capable of making one, it's the same test as revoking one as well. You have to be able to understand whether the person who you're proposing to be your attorney has a genuine concern for your welfare. And you have to appreciate that that person may need to make decisions on your behalf. And so you might not be capable of consenting to your own personal care decisions, but you still might be capable of consenting to make a power of attorney for personal care. Like I mentioned, capacity is different for different decisions. So although you might not be capable of making your own treatment decisions anymore, you could still be capable of making your own power of attorney for personal care to decide who you want to make those substitute decisions on your behalf. So there are some formal requirements of a power of attorney for personal care. It's a document, it's in writing, and the legal language that we use is you are the grantor. You're the one making the power of attorney, and you name attorneys or an attorney, more than one person if you want. You have to be 16, at least 16 at the time you execute this document. It authorizes the attorney to make personal care or treatment decisions on behalf of the grantor in the event they are no longer capable of doing so. You can grant full or partial decision-making authority. It can contain conditions and restrictions. So as opposed to applying to every decision, that could be limited. It takes effect only if you're incapable. And so on the slide, it says you can note your wishes about healthcare. And I wrote, but caution. And I'm going to talk about that a little bit later because in Ontario, we don't have living wills, and wishes expressed in a power of attorney document are not consent. They are wishes, and wishes can change over time. And so I'm going to talk about that a little bit more later, but that is something to note, that wishes can be included. You sign the documents in front of two witnesses, and the witnesses cannot be the attorney or the spouse or partner of the attorney, and it can't be the grantor's spouse, partner, or child, and it can't be somebody who's under 18 or who themselves is the subject of a guardianship for property and personal care, which I will talk about later as well. I'll explain guardianship a little more. So those are the formal requirements. And they're the same for revoking a power of attorney if you no longer want it to apply. There are prohibitions about who you can name to act as your attorney. So a person may not act as an attorney unless they are the spouse, partner, or relative of the grantor, if they provide health care for compensation, or residential, social, training, or support services to the grantor for compensation. In some circumstances, and I believe they are very limited, the public guardian and trustee, which is a government body run by the Ministry of the Attorney General, can be named as an attorney in a power of attorney for personal care, but it requires their consent to that appointment. So, like I mentioned, it's a document that only comes into effect when you become mentally incapable of making personal care decisions. And that is different than the continuing power of attorney for property that Graham talked about last week, which in general, unless it says otherwise, comes into effect immediately upon signature. So, choosing your attorney, you can name more than one attorney in a power of attorney document to either act jointly, which means they have to always agree and act together, or jointly and severally, which means either of them could act. They can act together or they can act on their own without the other one. If the power of attorney does name two or more people as attorneys, they act jointly unless you state otherwise in the power of attorney document. So you've got to be careful that what you're putting down is what you mean and what you intend. So if you name two people, but you don't specify joint and several, it will be jointly. If two or more attorneys act jointly and one of them dies or themselves becomes incapable of personal care or they resign, the remaining attorney or attorneys are authorized to act unless you've specified otherwise in your power of attorney document. And just some general considerations, sometimes people think that they want to have more than one person for accountability reasons, or they have a number of children and they don't want the other children to feel left out. But you really should speak to a legal advisor and really consider whether these people will make decisions together, whether they're on the same page, whether they get along, whether one of them is readily available and doesn't hold up the other one if they're jointly and can make these decisions, sometimes in a timely manner, or if there's a mechanism for dispute if they don't agree. These are things to consider when you're making a power of attorney for personal care. So choosing an attorney, this is really the key, is that if you're going to prepare one, you really need to trust the person or people that you name as your attorney. The wide-ranging powers that these documents give that have effect on your decisions about where you live, your healthcare, your food, the clothes you wear, what risks you're allowed to take. So these documents can be a very important way in which people protect their interests by planning in advance for when they become incapable. In some cases, however, the documents can cause conflict or unintended consequences. And part of this is sometimes attributable to a lack of appreciation of how far-reaching a document it can be, or failing to consider the extent of the powers that are given, or consideration about whether the attorneys will truly look after your best interests and the way that you would want decisions to be made, as opposed to how they want decisions for you to be made. And so choosing the right attorney is a very important step in reducing the risk of future abuse. Talking to your prospective attorney and getting a sense of whether you're on the same page on important decisions like end-of-life decisions, be able to make really tough decisions that they might need to make in the future if necessary. If there is no one that you trust with these decisions, you should really consider whether you need a power of attorney for personal care, and understand what the consequences are if you don't make one, which I'm going to talk about. Unfortunately, at ACE, we sometimes see people who are prospective tenants in a retirement home or long-term care home told they need a power of attorney. Do it right now. Your daughter's here, put her in there. And people sometimes feel pressured to do it, not realize how far-reaching these documents can be. Okay, so when does the power of attorney for personal care come into effect? This is where it gets a little complicated. So there's a law in Ontario called the Healthcare Consent Act, and that deals with 3 types of decisions: consent to treatment, long-term care home admission, and receipt of personal assistive services. So though in those cases, a consent to treatment, like I spoke about, a doctor, for example, will propose a treatment, and it's their duty to assess the capacity of the person who they're proposing the treatment for and obtain consent from that person if that person's capable, or their substitute decision maker if they're not capable. For long-term care homes, it's that person called an evaluator who makes that decision about capacity. And if a person is not capable, then the power of attorney for personal care would be triggered to make that substitute, and the person doesn't have a guardianship in effect, which I'm going to talk about. Now, so for these Healthcare Consent Act type decisions, there is a finding of incapacity by a particular person, and these findings can be challenged at the Consent and Capacity Board, which is an administrative tribunal. So there's some protections, and this is sort of set out. So your power of attorney document doesn't need to say consent to treatment is from a particular health provider. It's whoever is proposing the treatment who makes that assessment of capacity. Now, what about those decisions, the very important decisions like shelter or accommodation, nutrition, clothing, hygiene, and safety? Those are the other personal care decisions. So there's 3 different ways that the power of attorney could be activated. And so you look at the documents. And so number 1, no condition requiring incapacity to be confirmed. So the power of attorney document is silent about whether incapacity needs to be confirmed. And so in that case, the attorney can act when they believe they have reasonable grounds to believe that the grantor is not capable of making that clothing or hygiene or safety decision. Some power of attorney documents will specify a method for confirming capacity for these type of issues, the shelter, accommodation, nutrition, and it might be a particular individual, like a doctor or a class of people or a friend, for example, or it could be just a specified method. Things to watch out for is, what happens if that person is no longer around? What if that person can't be reached on a timely basis? But just to say, if a method is specified, that's who the attorney should turn to assess, to get the capacity assessed in that situation. And the third one is if it says capacity needs to be assessed, but doesn't say by who, then it must be confirmed by a capacity assessor from the capacity assessment office that I mentioned earlier. So these personal care decisions that don't come within the scope of the Healthcare Consent Act are very broad and can have a really big impact on a person's quality of life. ACE has seen cases where attorneys for personal care have used their authority to place a senior in a private care home with instructions that the senior is not allowed to leave or not have visitors or lawyers or even make or receive phone calls. Even in cases where the senior is residing in their own home, the attorneys sometimes use that authority to limit access to the senior or limit the senior's ability to decide who they want to live with. And we've also seen cases where the attorney will call the police and claim that a senior has been kidnapped so that the police can pick them up and return them to a certain place. And so they're very, not to say that the attorney is acting legally in those situations, but it's also hard to challenge this use of power of their discretion absent going to court, for example. And often because the person, if they're not capable anymore, to be able to speak up and raise the issues and get lawyers involved. And so unlike the Healthcare Consent Act decisions, there's no right to request a hearing before the Consent and Capacity Board for these type of personal care decisions. And like I said, a court remedy is available, but it's financially a barrier in many situations. Okay, so planning for incapacity. So who makes the decisions if you don't have a power of attorney for personal care and you become incapable? And so there's two main ways that I'm going to talk about. A court-ordered guardian of the person. Okay, so this is the most intrusive and expensive method of substitute decision-making for personal care for a person. It requires an application to the Superior Court of Justice. It's created when the court finds there's a legal determination that that person is no longer capable of personal care decisions, some or all of the ones that we mentioned, that they need a guardian, and it appoints a suitable guardian of the person. And full or partial guardianship can be given. So that means healthcare, nutrition, shelter, clothing, hygiene, or safety, all of those or some of those. A guardian of the person has the decision-making authority stated and outlined in the court order, and that could include custodial power, access to personal information, personal care treatment decisions, and any other powers specified in the court order. So it's a very large, it can be a very large intrusion on liberty. The public guardian and trustee, like I mentioned, is part of the Ministry of the Attorney General. They have a branch called the Guardianship Investigations Unit, and they can be called by any member of the public where there's an allegation that there's a person who is likely capable and at risk of serious adverse effects, property or personal care, but we're talking about personal care today. So serious illness or injury, a deprivation of liberty or personal security. And so the PGT can investigate, and if they have reasonable grounds to believe that there is an incapable person that is at serious risk, they can apply to become a temporary guardian of the person to prevent these serious adverse effects. And they can then apply later to continue that and make it more of a full guardianship. Guardians of the person, the court-appointed guardians of the person, and attorneys for personal care have legislated duties and responsibilities, and most of these duties overlap. They are significant, and this is in recognition of the inherent power imbalance between the attorney and the grantor, who at the time the decisions are made is presumably no longer capable of making these decisions. And so the legislation outlines what these duties are. They're set out in the Substitute Decisions Act. And so, for example, the duties include making decisions on their behalf, keeping records of decisions that are made, encouraging that the incapable person to participate to the best of their abilities in the decisions, seeking regular personal contact between them and supportive family members and their friends as well. That the guardian shall consult with supportive family members and friends who are regularly in contact. and from the people from whom the incapable person receives care. And as shall, this is a mandatory provision, as far as possible, seek to foster the person's independence, and that the guardian shall choose the least restrictive and intrusive course of action available in the situation. So the examples that I gave earlier of attorneys who are isolating the seniors from other family and lawyers and contact with the outside world, I was mentioning that that is contrary to their legal duties, but seeking a remedy for that can often be difficult. Okay, and so now I want to talk about treatment decisions, because in Ontario, when a person maybe doesn't have a guardian of the person, has not made a power of attorney for personal care, that person always has a substitute decision maker for treatment, for admission to long-term care, and for that other thing I was telling you about personal assistive services in long-term care homes. And so even if you have not made a power of attorney and there's no guardian, you will always have a substitute decision maker for these decisions. And that is different than property decisions that Graham talked about yesterday. There's no equivalent hierarchy of substitute decision makers if you haven't made a power of attorney for property, a continuing power of attorney for property. And so this list is set out in legislation called the Healthcare Consent Act. It contains a hierarchy. So if I'm the doctor and a patient comes to me and I'm proposing a treatment, I assess that they are not capable of consenting to that treatment. It's my duty to look at the hierarchy of the list and go down the list and find who is the appropriate substitute decision maker for this person in the circumstances. So you start at the top and work your way down. And I have to find one who's themselves capable, that they're available, and that they're willing to make a decision. And I'm going to talk a little bit more about that, about equally ranked decision makers having equal authorities. And if these equally ranked decision makers disagree, that the public guardian and trustee will step in to mediate or to make a substitute decision in that situation. So here is the hierarchy. So we start at the top with a court-ordered guardian of the person that I talked about later, where a guardian has been appointed by the court, and that court order has to allow for treatment decisions. So if that's the case, the doctor would take instructions from that guardian. But if you don't have one, you go down the list. Is there an attorney and a power of attorney for personal care, and the document allows you to make this type of treatment decision? Then you assess whether that person is capable, available, and willing. If not, there's somebody called a representative. And so the alleged incapable person himself or another person can apply to the Consent and Capacity Board, the administrative tribunal, and be appointed a representative for that treatment decision. And they have to be 16 years or older. Then you go, if that's not the case, then you go down spouse or partner. Both of those terms are defined in the law. And so spouse includes people who are married, people who are living in a conjugal relationship outside of marriage, but have cohabited for at least 1 year, or are together the parents of a child, or have entered into a cohabitation agreement under the Family Law Act. You're not a spouse if you're living separate and apart as a result of breakdown of the relationship. Partner means two people who have lived together for at least 1 year and have a close personal relationship that's of primary importance to both people's lives. And then we continue down the list, and we're talking about relatives. And so that's by blood, marriage, or adoption. And so like you can see there, you will always have someone on the list. And if there's nobody in your life that meets this criteria, then it's the public guardian and trustee. So it's not a circumstance where the doctor ever makes the substitute decision for you. There's a list if you're capable, you make it yourself. If you're not capable, they turn their mind to this hierarchy for treatment decisions. And so to be a substitute decision maker, and I'm sorry for writing SDM, that's the abbreviation because it's such a long term. The person in the highest in the hierarchy may only give or refuse consent if they are themselves capable in respect of that treatment, at least 16 years old, unless they're the parent of the incapable person. They're not prohibited by a court order or separation agreement from acting as a substitute decision maker. They're available. And so available means that the person is available, if possible, within a time that's reasonable in the circumstances to communicate with the person and obtain a consent or refusal. So living abroad these days isn't necessarily a barrier to being available, especially now during COVID with Zoom and different types of technologies. People can be available even if they're not present in the same city. And then willing, they also have to be willing to act. Some guiding principles, like I mentioned, if there's more than one person in the same category, so here's an example, you have 3 children, all 3 may act jointly, or they can choose one of them to be like the representative and make the decision, but they all have to agree. If they can't get unanimous agreement either to a particular decision or which one of them will act on behalf of the others, the public guardian might mediate or may be required to make that decision. So how does a person make a decision on your behalf when we're talking about treatment decisions and the admission to long-term care? It's not, what decision would I make for my mom? What do I think is the right decision? There's actually a legal test that substitute decision makers need to follow. And so the first thing is to follow any applicable wishes that were expressed when the person was capable. So do you know that they had any wishes that were applicable to this particular treatment or this particular long-term care home decision? If you don't know of a prior capable wish, then there's a best interests test. And that's where you consider the person's values and beliefs, their other wishes made while incapable, whether the treatment is likely to improve their condition, prevent them from deteriorating, reduce the extent of deterioration, benefits and risks. Is it less intrusive or restrictive? What happens if there's no treatment? So the substitute is the interpreter of the patient's wishes and has to determine whether the wishes were expressed while the person was still capable and made voluntary, whether these are wishes that are possible to fulfill, whether the wishes are the last known wishes or whether the person has changed their mind, what the patient meant by that wish. Sometimes people put in their power of attorney document, no heroic measures, and that's all they put. But what does that really mean? And did they, when you consider their values and beliefs in this particular case, is that what they meant by it? What does that mean in this particular circumstance? Did they have a change of heart after they wrote that in their power of attorney document? Maybe they mentioned to you, no, I'm okay. I feel like I can live with this for a lot longer. I'm not ready. And so they have to assess whether the wishes are also applicable to this particular decision. Did they know that they were going to have this particular disease at the time they made that wish? And so maybe it's not applicable to the particular decision. And so, like I said, if there's no applicable wish, prior capable wish, the substitute has to do that best interests evaluation. Wishes about future care can be expressed by any means. So I mentioned earlier, they can be put in a power of attorney for personal care. They can be put on a piece of paper. They can be oral by telling your substitute decision maker or another person, videotape, any other communication methods like ASL. And what matters in this situation is that it's the most recent capable wish. And so you can give this sort of absurd example where a person goes to a lawyer's office, prepares their power of attorney for personal care, makes some wish, no heroic measures, writes it in, and on the way out of the office says, actually, no, I'm okay with heroic measures. And so it's that last prior capable wish that counts. And so that's why you want to be careful if you're putting something in writing, if your wishes change later, to make sure that they're known to your attorney. So what's healthcare? Wishes, I mentioned earlier, wishes are not consent. Before treating you, healthcare professionals must get informed consent from you if you are capable, except in emergency situations, which I'll talk about in a minute. And consent includes the nature of the treatment, the benefits, the expected benefits of the treatment, the material risks of the treatment, the material side effects of the treatment, alternative courses of action, and the likely consequences of not getting treatment. That's what informed consent includes. If you are not capable in that health professional's assessment, they need to get that same informed consent on your behalf from your proper substitute decision maker. So even if you have a written advanced care planning document that expresses a wish, they still need to get consent from you if you're capable, or your substitute decision maker if you're not capable at the time the treatment is proposed. So like it says there, wishes are not consent. Wishes are wishes. Consent is when you're getting a healthcare consent, the person giving it interprets those wishes at the time the decision is made. Advanced care planning can only be done by you, not your substitute decision maker. And so what advanced care planning means for you is preparing a power of attorney document, if that's what works for you, if you have someone you really trust or somebody, multiple people, or if you don't, looking at that Healthcare Consent Act hierarchy and seeing who's highest on the list. And if it's someone you don't want, maybe that's a case where you might want to prepare a power of attorney document, or you want to solidify your choice by making one. So it's knowing what happens if I don't prepare this document, who will be my decision maker? And if I want one, do I really have somebody I trust to make the right decisions for me? And then the second part is expressing your wishes about your future healthcare and communicating your values and beliefs on an ongoing basis to the attorney you've named. And that's really important. People often don't want to talk about these really heavy issues about illness and end of life and values and beliefs, but it's really important if that person is going to have to interpret those decisions for you when the time comes that they have to make a substitute decision for you. So it's really important. That's how advanced care planning is done in Ontario, by continuing to have that conversation with your substitute decision maker. And so earlier I mentioned emergency treatments. And so that's if a person is experiencing severe suffering or at risk of serious bodily harm, and it can only be given without consent, where the delay to obtain substitute consent or refusal would prolong suffering or risk serious bodily harm. It's available where the person is capable but also not able to communicate due to a language barrier or disability, but it should be really rare. And really, if consent can be obtained, it should be. So finally, there's some really great free resources out there. I'll plug our website, which is, we're going to have a brand new website soon, but we still have some really, really helpful documents on our website that covers a lot of the same information that I've covered today. There's Community Legal Education Ontario that has really helpful booklets on powers of attorney. They have one specifically on power of attorney for personal care. Information from the public guardian and trustee as well, substitute decision-making on guardianship, living wills, which are not a thing in Ontario, which I hope that I've covered in my presentation earlier. And then our newsletter, which is available on our website. And the last thing I just wanted to mention that I didn't, it was about when you're making power of attorney documents or you're considering doing it, if it's within your means, would always recommend going to a lawyer to prepare them, because they have such big authority. They give such big authority over your life on such personal and important issues. And the wording can be tricky and unintended consequences can happen. And so it's an investment in ensuring that things don't go awry down the road. And there's a lot of resources in legal aid for people who cannot afford lawyers, to contact your local legal clinic or ACE if you want more information about free legal clinics that do wills and powers of attorney. But I would stress the importance of legal advice, even though these documents can be prepared by people on their own as long as they meet those formal requirements I mentioned. But because we see things when things go wrong, that when unintended consequences happen, I would really highly recommend getting legal advice. And so that is the end of the talking part of the lecture part, and now is the question part of the presentation.
Hi, Karen. That was fantastic. Such a great topic. We do have some really good questions here. The first one is regarding the hierarchy of treatment decisions. Why would a court-appointed guardian come before the attorney for personal care? What would the circumstances be?
Okay, so I put the hierarchy back up. So in general, if there was a power of attorney for personal care in place, there may not be a need for a court-appointed guardian of the person. However, let's say there were allegations of abuse or impropriety by the attorney. They weren't carrying out their duties. They weren't taking care of the person. That person was at risk of harm. In that case, the court may order a guardian of the person to step in. And so that's why it's really the highest ranking, because a court has determined the incapacity, has determined whether there is a power of attorney in place, and has determined whether that person is suitable or not, and makes that order. I don't know if Jane has anything to add. I've got Jane Meadis also. I saw she popped into the call, but that's why it's sort of the biggest restriction on liberty and the most possible. It's the most serious and most expensive route, and it would really only be in place if there was a power of attorney before, if there was some concern like that power of attorney wasn't valid, the person wasn't capable when they signed that power of attorney. And once someone is no longer capable, we talked about what the capacity was for making a power of attorney document. No one can make that for you if you're not capable any longer. And so in that event, the route to get the authority to make the decisions would be to go to court and become that person's guardian of the person. Does that make sense? Did that answer the question?
So I was just going to add a couple of things. One, another reason would be if there are co-attorneys. So if power of attorney names two or more persons and they can't agree, so there's some big dispute, that might also be a time that they would go to court, and that there would be a potential granting of a guardianship. And just to clarify, so just what Karen said. So that's like for a full guardianship. If it's just a decision with respect to treatment or placement, one of those things that the Healthcare Consent Act does, you don't have to go to court. If there was nobody, like somebody could always go to the Consent Capacity Board to be appointed, which is a much cheaper, faster, easier route. So those are really, court is really expensive, takes a long time, and is really only for the most serious cases where there's a lot of problems.
I think that might actually answer the next question, which is, does the Consent and Capacity Board have any role when 3 children required to act jointly cannot agree?
It depends if you're talking about like a Healthcare Consent Act decision, or a decision, we talked about those non-Healthcare Consent Act Substitute Decision Act decisions. So the Healthcare Consent Act decisions, like treatment, admission to long-term care, and personal assisted devices in long-term care, I think there could be a route for an application at the Consent and Capacity Board, but not for those the Substitute Decisions Act agreements. Am I right in that, Jane?
Yeah, and I would say that generally, if it's something under the Healthcare Consent Act, so what Karen said, and personal assistance services is both in long-term care homes and retirement homes, or admission to long-term care or treatment. If they can't decide, it's actually the public guardian and trustee who becomes the decision maker. It would be possible, for example, to do like a Form G application, but the board won't deal with like the dispute itself. They could possibly, like I said, do an order under Form G, but they'd more likely, I've never seen that. It normally would go to the PGT as a decision maker. It would be I've never seen one going just on that issue of a disagreement. So that would have to be a Form G, would be the only way it could go.
And the next question, Karen, is about the wishes that you were speaking about and whether they need to be witnessed.
No, they don't. And so I just talked about, I mean, if they were put into the power of attorney documents, the power of attorney needs to have its formal requirements. But like I said, it can be oral. And I gave that example of how you can write it and have it witnessed and then orally change your mind on the way out from the office. And it's that last prior capable wish that is applicable to the decision that's important in the legal determination of the substitute decision at issue. So it doesn't need to be witnessed. It can be made in any form. The only thing that needs witnessing and writing is the power of attorney document itself.
The next question is, if a power of attorney for personal care is not in place and the courts or a guardian have to be brought in on the person's behalf, who pays for this?
I think that it's usually the person's estate. Am I right?
Yeah, I mean, I think, normally what will happen is that whoever is applying is going to have to cough up the money. At the end of the day, they may able to get it out of the person's estate, but it would depend on the person's estate, whether they had the money. So whoever is applying would definitely have to be considering footing the bill, at least initially, until the court ordered it come out of the estate or something, and that's usually that would be up to the court to determine. But again, going to court, the simpler route is because it usually has to do with treatment or placement into long-term care, and the Consent Capacity Board is always the easier route and cheaper route there. So it's only in cases where it's some other kind of personal care issue and it doesn't come out of the Healthcare Consent Act that you'd have to do that.
And the next question is about whether any of this means that close friends cannot be appointed as a power of attorney.
No, just the restrictions that I mentioned earlier about people performing home care sort of things for compensation, unless they are the spouse or partner or relative of the person. And as long as they themselves are capable and over 16 years old, there's no requirements it can be your friend as long as you trust them.
The next is a comment and then a follow-up question. Resuscitation plan of care documents used by hospitals and long-term care facilities seek consent for future circumstances, not a treatment decision that needs to be made in real time. The follow-up question to that comment is, how is a power of attorney supposed to manage the request to answer these questions about future potential circumstances and treatment decisions?
I'm going to lob that to Jane because that's her wheelhouse.
So these are the often a level of care forms, and they may, in long-term care, they're usually called like a level of care form, something like that. In hospital, it usually has more to do with the resuscitation issues. So it depends. So if the person had a capable wish, you can certainly indicate to the home or the hospital what their capable wish was. And then they can note that. If it's part of a plan of care, you can include that. So, for example, if someone has congestive heart failure and you know that they're likely to have heart failure or has some other kind of a disease that's going to they're going to end up being sick and, resuscitation. So COVID would be a good example. For example, somebody could have, that could be part of the treatment plan. If that happened, do you want them to go on to resuscitation and sort of things? But so a substitute can make that as a plan of care because they know that it's part of the process and that like a progression of a disease. But if they're just saying, oh, your mom's coming into hospital to have her, her ankle set, but if she, do you want her to be resuscitated? Those two things don't have much to do with each other in general. And so you couldn't make a document, you could not sign, you can't make a wish, you cannot give instructions on that. They have to wait till the time. So if you don't know what they wanted, there's nothing you can do and you have to tell the home you can't do it. And that's the problem with those documents is they are asking people to make decisions about future care that are not appropriate and aren't frankly legal.
Thank you. And we've got one regarding the decisions for hospital discharge destination. So for example, long-term care home, retirement home, or back to their home in the community. If attorneys cannot agree, is this a Healthcare Consent Act or a Substitute Decisions Act, or does it come under something else?
Do you want me to answer that one?
Yeah, I can guess, but I feel like you know the answer.
Well, I don't know that there's a really clear answer. So, whether, discharge destination is not a Healthcare Consent Act issue. And it may or may not be under the Substitute Decisions Act. Again, it could be, for example, under housing. And if they can't agree, it could end up in court. That would be a situation where if the attorneys totally can't agree and they want to fight it out, that would be a situation where they might end up in court because it would not be Consent Capacity Board. PGT would not take a position. If it's long-term care admission, it does come under it, sorry, but if it's any other kind of place. And discharge from hospitals generally kind of a tricky one because the hospitals will often tell people that they have to make choices, for example, with respect to going into a retirement home or something where really what they want to do is go into long-term care or frankly return home, and the hospital may be trying to get them to do things that they're not allowed to do. So if a person's entitled to go to long-term care, that's what they're entitled to do. They don't have to go home or to a retirement home to wait. And so that's often conflict there.
Great, and that's all the questions we have in the Q&A. I'll turn it back to Kimberly.
Okay, it looks like everyone's asked their questions, and I'd like to thank everybody for coming to our second in the series. We have another one in a couple weeks, and I'm sorry, I probably should have had that date in my head. We will be receiving a follow-up email asking if there's any suggestions of future topics you'd like to hear, if you enjoyed this session. If people can fill those out, that would be great. Our next session is going to be on November 16th. And it is in regards to aging gracefully, when someone can make these decisions, when someone can make legal decisions for you. Thank you for everyone for coming, and hopefully we see you in a couple weeks. Bye.